Our topic is the German reaction. Wir schaffen das were the iconic words of Chancellor Merkel in the refugee crisis 4 years back. And now in the COVID-19 crisis, the phrase returns with the question mark, schaffen wir das? The German legal and constitutional order is challenged in many ways by the current crisis, and the aspects of this we will discuss today with our distinguished guests. There's Sabine Leuthauser-Schnarrenberger, who probably needs no introduction. She was for many years the Federal Minister of Justice and a fierce defender of civil rights and liberties within and without this office. And she will open this round with a brief introduction on COVID-19 and the German constitutional order. Next, our hosts, Pierre Thielberger and Benedikt Behlert, will speak about the German constitution and whether or not its emergency regulations, or Notstandsverfassung, is fit for a pandemic crisis like the current one. Pierre Thielberger is a professor of public international law at the University of Bochum and the executive director of the Institute for International Law and Peace, of Peace and Armed Conflict, IFHV. And Benedikt Behlert is a researcher at the same institute. And I thank both very much for coming up with the idea and organizing this discussion series. Christoph Möllers is a professor of public law and legal philosophy at the Humboldt University of Berlin and a permanent fellow at the Wissenschaftskolleg. And he's also a public intellectual and probably one of the most visible and well-known faces in German constitutional law. And he is a friend and support and author of Verfassungsblog since the very early days. And he will talk about the German parliament, the Bundestag, and how it fares in this crisis. Andrea Römmele is the only political scientist on this panel. She is a professor of communication and politics and civil society at the Hertie School in Berlin. And her research is focused on political communication and political parties, which will also be the topic of her input today, the implications of the COVID-19 crisis for the German political and party system. And last but not least, Annika Klafki, junior professor of public law at the University of Jena and a specimen of a very rare and extremely sought after breed that is public lawyers with an expertise in public health. Her research on risk and catastrophes and pandemics is obviously in high demand in these days, and her topic today will be the recent amendments to the German epidemic emergency law under the question, an antidote with deadly side effects. I am Max Steinbeiß, chief editor of Verfassungsblog, and I have the honor to moderate this panel. And before I give the virtual floor to Ms. Leuthauser-Schnarrenberger for her initial statement, a few practical remarks. You, the audience at home or wherever you follow this live stream, are warmly encouraged to participate in this debate, to ask questions to our panelists, and you can do so either via Twitter using the hashtag IFHV, or directly here on Verfassungsblog by using the comments section. And now, without further ado, to Ms. Leuthauser-Schnarrenberger, who will speak German as befits a German topic, whereas all other panelists will speak English in their statements. Ms. Leuthauser-Schnarrenberger, the floor is yours.
Oh. And you have to put your microphone on.
No. Okay, thank you so much. Yes, I will start in German with my short statement. Besondere Situationen wie die Corona-Krise haben natürlich besondere staatliche Maßnahmen erforderlich gemacht. Und mit dem Lockdown kam im März, Anfang März, das gesellschaftliche, das öffentliche, das soziale, das berufliche Leben weitestgehend zum Stillstand. Also eine besondere Situation für alle Bürgerinnen und Bürger in Deutschland und ein Stresstest für die Grundrechte. Und ich will in meinem kurzen Statement den Blick gerade auf die Grundrechte als wesentlichen Teil unserer Verfassungsordnung in Deutschland richten, denn andere Teilnehmer des Panels werden sich mit dem demokratischen Aspekt der Legitimation, auch mit der Frage der Gesetzesgrundlage für das Handeln des Staates in dieser Krisensituation intensiv befassen. Stresstest für Grundrechte, ja, denn mit dieser Infektion, mit dieser im März ansteigenden Zahl an Infektionen und der ersten sehr strikten Reaktion des Staates wurde doch in eine Vielzahl von Grundrechten nicht nur eingegriffen, sondern manche konnten über eine gewisse Zeit überhaupt nicht ausgeübt werden. Das hat es bisher in Deutschland in dieser Dimension nicht gegeben. Und es ist wichtig klarzustellen, anders als in manch anderen europäischen Staaten, in Deutschland gelten auch angesichts solch großer Herausforderungen die Grundrechte. Sie treten nicht automatisch hinter dem wichtigen Handeln des Staates, der in solchen Situationen ja der erste Krisenmanager ist und was auch von den Bürgerinnen und Bürgern von ihm erwartet wird. Aber es gelten auch in diesen Situationen die Grundrechte. Das heißt, zuallererst entfalten sie ja die Wirkung, als Bürger sich auch gegen staatliches Handeln wehren zu können, Schutz zu haben vor zu tiefen Eingriffen in unsere Freiheitsrechte. Und das, was wir erlebt haben, das bezieht sich gerade auf März mit der totalen Beschränkung der Bewegungsfreiheit durch Kontaktverbote oder Ausgangsbeschränkungen, mit einem tiefen Eingriff in die Berufsausübungsfreiheit für viele Menschen, für Gastwirte, für Geschäftsinhaber, für Fitnesstrainer, für auch gewisse Gesundheitsberufe. Die Religion konnte nicht so gelebt werden, dass man auch Gottesdienste aufgesucht hätte. Also die Religionsausübung, in die wurde tief eingegriffen. Und auch das Recht, sich zu versammeln, das Demonstrationsrecht. Grundrecht Artikel 11 unserer und Artikel 8 unserer Verfassung, Entschuldigung, 11 ist die Freizügigkeit, die ist auch berührt, hatte es auch in dieser Form, dass es ein pauschales Versammlungsverbot gegeben hat, in Deutschland nicht bisher gegeben. Dass es Auflagen zu Versammlungen gibt, ich komme gleich noch kurz darauf, das ist selbstverständlich und Praxis. Und dieser Stresstest für Grundrechte, ist das so normal? Muss man das einfach hinnehmen? Die Gerichte in Deutschland, und es gilt die Rechtsstaatsgarantie, der Weg zu den Gerichten, die Rechtswegegarantie, Artikel 19 Grundgesetz, auch in diesen Krisenzeiten, wo der Staat anders handelt als vielleicht sonst bei Herausforderungen, gilt auch die Rechtsstaatsgarantie. Also Bürgerinnen und Bürger können sich an Gerichte wenden. In diesen ersten Wochen haben die Gerichte, vorwiegend Instanzgerichte, teilweise auch das Bundesverfassungsgericht, in einstweiligen Anordnungsverfahren, alle anderen Verfahren dauern ja sehr viel länger, mit einer vorläufigen Abwägung zwischen einerseits dem wichtigen Ziel, was all mit diesen Maßnahmen verfolgt wurde, nämlich auch die Gesundheit und das Leben vieler, vieler Menschen zu schützen, aber auch das Gesundheitssystem stabil zu halten, abgewogen mit den Freiheitsrechten, ich habe sie kurz eben skizziert, die beschränkt werden für den einzelnen Menschen. Und in dieser Abwägung, und das ist ein wichtiges Element unseres Grundrechtsschutzes, abwägen zwischen unterschiedlichen Interessen, spielte dann das Verhältnismäßigkeitsprinzip eine wichtige Rolle. Das heißt, war die Maßnahme der Lockdown, alles stilllegen, am Anfang geeignet? Ja, ohne Zweifel. Dann, wenn man sich nicht trifft, kann man sich nicht infizieren. War es aber auch angemessen? War es auch erforderlich? Gibt es mildere Mittel? Darüber kann man diskutieren, aber die Gerichte haben in den ersten Zeiten gesagt, also das ist vertretbar. Also ein Stresstest für Grundrechte, der in den ersten Wochen überwiegend, soweit Gerichte mit befasst waren, auch als vertretbar angesehen wurden. Ich bin der Meinung, von Anfang an, als dieser Lockdown entschieden wurde, musste immer sofort mitgedacht werden, was heißt das für die Grundrechte und wie entwickelt sich die Situation. Man muss sofort immer mitdenken, auch wieder Öffnungsperspektiven, wieder Zulassung von Freiheiten, also sprich Zurücknahme von Beschränkungen zu haben, damit diese Grundrechte gelebt werden können. Das hat man nicht in der Politik wirklich so gesehen. Da war man eher auf der sicheren Seite mit dem Blick auf Infektionsrisiko minimieren, wenn man erstmal mit strikteren Maßnahmen agiert. Jetzt hat sich die Situation entwickelt, denn diese Grundrechtseingriffe können in dieser Massivität natürlich nur für einen ganz vorübergehenden Zeitraum auch vertretbar sein. Deshalb Befristung unverzichtbar, dauernde Überprüfung unverzichtbar und verfassungsrechtlich geboten auch immer die Öffnungen, also wieder mehr Freiheiten zulassen. In dieser Phase befinden wir uns. Da geht es nicht um ich sage jetzt nicht Orgien, um Öffnungslust, sondern da geht es darum, auch dem verfassungsrechtlichen Gebot, Freiheitsbeschränkungen auf ein Minimum zu begrenzen, auch gerecht zu werden. Und dann muss der Einzelne, und das ist mein letztes Wort, auch verantwortungsbewusst mit diesen Grundrechten, die er ja lebt, die er hat, die er dann wieder leben kann, auch umgehen. Und das ist dann vielleicht nachher noch eine aktuelle Diskussion zu dem, was wir jetzt in Versammlungen, das Versammlungsrecht ist mit Auflagen natürlich wieder zugelassen, das geht gar nicht anders. Und auch wenn Idioten sich daneben benehmen bei Versammlungen, wird man dennoch nicht Versammlungen aus diesem Grund verbieten können. Also die Grundrechte, ja, sie haben eigentlich diesen Stresstest einigermaßen ausgehalten, aber es ist trotzdem eine, in meinen Augen, doch schon sehr angespannte, auch wirklich mit Risiken behaftete Situation gewesen. Und es ist gut, dass doch auch nach einer anfänglichen, ich sage mal so ein bisschen Schockphase, dann am Ende doch eigentlich so unser normales Prozedere eben auch zu Gerichten zu gehen, jetzt wieder ja zum Alltag mitgehört. Es sind über 1000 Gerichtsverfahren anhängig. Und ich denke, neben diesen einstweiligen Verfahren, die nur diese Abwägung vornehmen, wird es dann auch schon noch mit einer natürlich deutlicher Zeitversetzung die ein oder andere vielleicht auch Grundsatzentscheidung geben. Aber das ist heute noch nicht zu beurteilen. Und damit möchte ich eigentlich eine Einführung mit dem Blick auf einen Aspekt unserer Verfassungsordnung, nämlich des Grundrechtsschutzes in Corona-Zeiten beenden. Vielen Dank.
Thank you very much, Sabine Leuthauser-Schnarrenberger. Stress test for fundamental rights. Sorry. How well is the constitutional order of the Grundgesetz prepared for this crisis situation we're right in? Pierre Thielberger, Benedikt Behlert, the floor is yours.
Yes, so in case you were wondering whether this is live or not, now you have the proof that it is live. Yeah, thank you so much to Max Steinbeiß and Benedikt Behlert, with whom we had this idea to do this format. It's also a test for us, so please let us know afterwards whether you liked it or not and what worked well and what didn't. Benedikt and I have, of course, the challenge that we have 10 minutes for 2 people. So we'll have to be very brief. And in order to force ourselves to be brief, we did a little PowerPoint so that we don't say more than we have agreed beforehand. So the plan for today is threefold in the next 9 minutes that are left now, to do 3 things. First of all, Max Steinbeiß reminded us that there will probably be a lot of people be watching now who are not so familiar with the German system. So for the argument that we are making, we want to highlight a few features of the German political and legal system that the German lawyers in the room are very well aware of. Apologies for this boring stuff that you all are very much aware of. But we think for international listeners, who we know we have also many, we wanted to highlight a few things. And then we want to make essentially 2 arguments, and that is that we see shortcomings. Shortcomings, once, vis-a-vis the current state organization. Obviously, we're not going as far as some politicians that have claimed quite radical things, but we do see certain dangers in the way the German system can or cannot react to the current crisis. And then secondly, leading back to the talk that Ms. Leuthauser-Schnarrenberger just gave, potential shortcomings also for the German case vis-a-vis the protection of its fundamental rights, the German Grundrechte. And with that, I give the first time quickly to Benedikt for highlighting a few features of the German system for those of you who are not so familiar with it.
Thank you, Pierre. Thank you, everyone. So just a very brief handful of facts on the German constitutional system and the way it handles emergencies. So the first thing to make very clear is that there is a very strong emphasis on the decentralization of power in our constitution. That means on the one hand that we have very pronounced federalism, which we see most importantly in the general competence for legislation and administration of laws lying with the Länder. And politically, we often see that in great political differences between the Länder. And we have a very pronounced separation of powers in our basic law. And with that comes a hesitation regarding concentration of power with the federal executive in times of emergencies. We have very limited emergency provisions in the Grundgesetz, and there is a distinction between external and internal emergencies. For the external emergency, that is the territory of the Federal Republic is attacked by another power, there are a few more things that the federal government can do, and that there are some simplifications in certain procedures and processes that are envisaged by the Grundgesetz there. But for the internal emergencies, the regulations are really very limited. The federal government can, under very narrow circumstances, take command over the police of a land, or it can send even the army to that land, but limited possibilities to do so. And generally, we want to make this very clear that this is a very good state of the art, that it's very important. These are lessons well learned from the times of Weimar and National Socialism. However, Pierre? Pierre, I think you have to turn on your microphone.
Yes, typical mistake. Sorry. So yeah, good. I think that's important. We don't want to be perceived as criticizing federalism here. Generally, that's a very good thing. However, we do see certain risks, certain shortcomings in the current system. Other observers have different opinions on this, of course. And one relates really to the flexibility of state organization in terms of a pandemic. So that relates first to the relationship of the federal state and the Länder, and secondly also how, and I think Christoph Möllers is going to talk about this much more with regard to the Bundestag, how certain state organs can or cannot organize themselves in times of crisis. And the second shortcoming that we want to point to is vis-a-vis the fundamental rights, the Grundrechte in Germany, because different from what we see in many human rights treaties, the German Grundgesetz does not have a specific derogability clause, so clause in which it says during these times of crisis, certain human rights can be deviated from, and that might or might not be good. We'll discuss that in a second. And altogether, I hope you get this little joke there. This is a child that is being thrown out with the bath water. I hope that's also a saying in English, by the way. In German, it is a saying. And that is supposed to say that obviously we do not want to demand more power for the federal executive. That's not our point. Our point is that what we see currently is that the lack of rules in certain areas has led the government to do more than it should do. So for instance, rather than concentrating certain powers on the government, what it has done in the absence of rules is concentrating power onto one single ministry, namely the Ministry of Health. And I'm sure that Ms. Klafke will talk about that later, which is of course highly problematic. So the first point, state organization. First of all, we have to, of course, say that the system is currently working. There is no doubt about that. Federalism works. However, what we want to emphasize is our impression is that maybe this working and this functioning is a bit less stable than some of us think. And maybe in the future, we might not see it this way. Two arguments here. First, keep in mind we have in Germany at the moment, the rare, in theory, rare situation of a grand coalition. What does it mean? We have the two big parties governing not only the federal state, but we have in all of the 16 Länder also a government which has one of the two parties in government. So naturally, there isn't so much conflict between the federal governments and the state governments, the Länder governments, because one of the parties in federal government is also leading, or at least part of the government in the Länder. That's point one. And the other thing, of course, we hope you forgive us this slightly pointed picture here. Don't forget that we live in a time where we have the rise of a party which has in its recent behavior, if you think about Thuringia, which is not so long gone, has actually demonstrated that it might not be willing so much to cooperate and show goodwill towards democracy. So we are a bit worried about what happens if these parties become stronger. So our point then is that we do need moderate competence shifts potentially and procedural simplifications in the legislation. I'll give an example maybe where this has happened. Maybe you have followed that, of course, we have at the moment parliament of 709 members, the biggest parliament we've ever had. And a lot of people have said that it's too big already. And in theory, the quorum previously was half of the members, but that has now been changed to a quarter. And that, of course, makes a lot of sense. The question is, of course, whether that is enough. We don't see other rules that would also be maybe could also make sense. For instance, for what is currently discussed as pairing, that is all voluntary rules, if you like, and they are not fixed anywhere. And the basic point essentially of this is to say, well, if we have all those rules for external emergencies, and we all know they are not good. I mean, if you look into them, if you do some research on them, they don't work very well. However, we have rules, and we don't have rules for the internal emergency. And that you might also question whether that really makes sense. Think about it this way. If the current pandemic that we have wasn't one that naturally evolved, but if it had been like an attack by another state as a biological weapon, the effects that you would have on people, the effects you would have on the state, on state organs, might be exactly the same. However, how we treat this situation, the legal framework we are in would be entirely different, because we could easily qualify that then as an attack, and then Article 115a, so essentially the external emergency might potentially apply. So we don't really see the reason for such distinction. And then as a kind of outcome of that, what we propose is not to do this like very fast reforms of laws, and I think Klafki will talk about that, but what we need, we think, is a discussion on how for the future we can better adjust the system. Again, and all of that is to be understood not as, giving more power to the federal executive, but rather to prevent that this is done in the absence of rules.
Thank you. As regards our second argument, Pierre, you have already mentioned that there is no state of emergency provision for fundamental rights in general. There are a few specific provisions. For example, for Article 11, there is a specific provision for how to curtail that right in a situation of crisis, but there is no global provision allowing for a derogation similar to the one that you would find in the European Convention on Human Rights, for example. And that leads to a situation where measures that are taken to address a crisis are all subject to the normal regime of fundamental rights implementation. They are all subject to the normal standards. Now you might wonder, why would human rights lawyers, why would people who are concerned about the best possible protection of fundamental rights criticize a lack of a provision allowing for a temporary derogation? The idea behind that is that a lack of a distinction could lead to a creeping normalization of emergency measures. When you do not have a clear distinction between normal times and times of crisis, you might see the standards that is being applied in a time of crisis that is, as we have seen, and as the minister has pointed out in her introduction, we have seen that the standard for assessing the legality of the measures taken to address the crisis has factually shifted or changed quite generally in favor of the public interest, in favor of the public good in the past weeks, most importantly in March. And we think that is therefore important to have a clear distinction in the form of a well-designed emergency provision that could prevent that, and that would add important limitations on crisis measures, explicit limitations, and that would, on the other hand, fulfill a crucial warning function also addressed at the general public. Hey, the measures that are taken, they are temporary, they are exceptional, and they will not last, but they will have to be lifted once the crisis that they are meant to address is over. Thank you very much for your attention.
Thank you very much, Pierre and Benedikt. Christoph, much has been talked already about the legislative branch of government, which is supposed to control the executive in its hour. So the floor is yours.
Yes, thank you. Yeah, I was a little bit thinking what to talk about under the heading of Bundestag and COVID, and I thought I just will not talk too much about the self-organization of the Bundestag, and rather talk about the function of the legislative branch on the state and the federal level, because I think that's what is happening at the moment, and we can come back to that in the debate otherwise. So I think we can all agree that the function of parliaments are somehow twofold. Basically, it's about giving a legislative program, especially for politics, especially giving a legislative program for the distribution of abridgment of rights on the one hand, and on the other hand, controlling the government, so reviewing what is actually done, what is done by the execution of the very legislative program that has passed parliament. So these are the two main functions. And I think it's fair to say that both of these functions at the moment are somehow in question. It is very important that in Germany we have, for the non-German viewers, we have a very fine-grained, in a way over fine-tuned doctrine of when we need a legislative statute. So we have a whole doctrine of Gesetzesvorbehalt, kind of a domaine réservé for the legislative parliamentary statute, which has been developed since the 19th century and has become in a way more and more extensive. Contrary to the fact that we have a parliamentary government, it has become more and more extensive. Since the 70s, even more so. And now we have basically a doctrine that says every abridgment of a right has to be foreseeable, the measures have to be foreseeable. Basically, you have to, when you look at the statute, you have to know what can happen to you. And this seems to be in quite a flagrant violation of what is actually going on. And I don't want to say too much about the Infektionsschutzgesetz. I think Anita Klafke will say a bit about that and its reform. But what I just want to mention is that there was one reform some weeks ago, and the basic norms that somehow allowed for some kind of abridgment of rights were not really changed. They were formally changed, but with a comment by the legislature say, this is just nominally, basically the whole law remains the same. Now, if you had asked someone in January 2020, if you close down the country, you prohibit religious freedom, you prohibit to leave your house, you prohibit business in January, can you do that with a statute? Everyone would have said, no, you cannot. Now, people have changed. Some people have changed their minds. They are lawyers, but on and on, I think we can assume that these police powers that are look very much like classically police statutes in Germany, and didn't really foresee this kind of intervention, and didn't really were made for this kind of move, for this unforeseen and in a way unprecedented abridgment of rights. Now, what has happened now? I think it's the political process is still there, and what we can see is over the last weeks that the kind of abridgment of rights is changing all the time. So basically, every 1 or 2 weeks, we get a change of what is law of the states in that case, which is done on the basis of regulations. The political process that is somehow programming that is an inter-federal debate between the chancellery and the chancelleries of the states, basically of the chancellor and the prime ministers of the states. So what we here have is a political process, but this is a political process that is purely executive. It's without any public, because we never really learn what they tell. We get some info about it, but it's never really public. And it's never really with reason giving. So we get a press conference, but we never get formalized reasons for that. That is the statutory basis of the whole thing. And this is obviously something which is on the one hand quite typical for how German federalism works. It's an executive federalism. Very many things are somehow done in that way, but they're always done informally in advance. They are not done as a matter of, in a way, legislative procedure, which is now has become. Because what we now see is basically on the basis of a very general statute, we have this intra-federal political process between chancellor and prime ministers, which is then produces some results that then become formalized in the form of a state regulation. It's not a state statute, but a state regulation. That leads to the fact that neither the German Bundestag nor the state parliaments are somehow involved in that process. And this is something, I think, quite amazing and runs somehow afoul of all the assumptions we have had so far about how this all is going. Now, is there a solution for that? And can we somehow make some proposals to change it? I think we can. And I think it is quite amazing that the state parliaments have not really discovered that their potential role in that whole game could be much wider. First of all, I think it's fair to say, and it's actually explicitly foreseen in the German constitution, that the regulations that are now done by the state governments on the basis of the federal statute, the very general and not amended federal statutes, could be done by state law, by parliamentary legislation. That is explicitly seen in Article 18, Section 4 of the German constitution. When the states are empowered to regulate parliament, state parliaments can do that. Secondly, there are, I think, ample possibilities for state parliaments to somehow I would say that accompany that process by saying, okay, every week we want to have a report, what is going on. Or every 2 weeks we somehow have to have a vote on what is actually here taken by the state government in order to get some grip on what is actually happening. Because what we see at the moment is not only that parliaments do not act as a legislator, they also do not act as a reviewer of governmental actions. So scarce anecdotal evidence I only could collect from, let's say, Lower Saxony and Hessia and Baden-Württemberg tells me that basically parliamentarians don't really know what is going on. They don't have any comprehensive account of the way state governments execute this thing. And when I ask them, so what are you doing actually in Hessen at the moment? So why don't you get more information? They say, well, basically what we do is we have some question, and then it takes 3 weeks to get an answer, and 3 weeks later everything has changed. Fair enough, but there are solutions for that, and there are even statutory solutions for that in a way organizing other different review processes that could help Parliament to be better informed. So as a matter of fact, there is a structural problem, which is an old problem. That is the fact that the execution of federal statutes cannot be reviewed by federal parliament because federal parliaments, they're executed by the states, and cannot really be reviewed by state parliaments because it's a federal statute. There's a gap, and that is a gap that has been much described in the description of German executive federalism. Still, there are means to somehow close that gap or to at least mitigate that gap. And these would be both on the legislative programming side as well as of the side of legislative review of executive action by the states, so that the fact that the parliaments don't do anything at the moment remains a little bit of a puzzle for me. Thank you.
Thank you very much, Christoph Möllers. Executive federalism as opposed to legislative procedure and political deliberation and public communication in general. We're leaving the camp of the legal discourse and talk about the political system, and this is your topic, Andrea Römmele.
Yeah, thank you very much. Nice to be on this online panel. Pierre, you gave me the task, the implication for the political system in 10 minutes. As I think we also have listeners coming from outside of Germany, I think I'll take a couple of minutes to actually elaborate a little bit on the situation, on the political situation we actually had before COVID-19 hit. The Greens, that's my first point, were on their all-time high a couple of months ago in the polls, actually at the same height, more or less, the CDU-CSU was, and the Greens already were talking about, who could be or who will be our chancellor candidate. Actually, in 1 month, I think it was in September, I think it was with Infratest DIMAP, they were 1% even above the CDU-CSU on their all-time high. First point. The second point is that the CDU actually was a scattered party, ununified, had loads of internal problems. Annegret Kramp-Karrenbauer, the preferred successor from
the perspective of Chancellor Merkel, had to step down as party chairwoman. Yeah, a completely ununified party and a completely ununified grand coalition. And all we were talking about was actually, will the grand coalition actually hold until the next federal election in the fall of 2021? We had, and that was February, remember, we had this big scandal in Thuringia. We had the three state elections last year in East Germany, in Thüringen, Sachsen, and Brandenburg, where the AfD in most cases doubled, in one case even more than doubled their results. Most of you know that, most of your listeners know that this all culminated in Thuringia, where the AfD supported an FDP candidate for prime minister, and the state of Thuringia even made it onto the front page of the New York Times, and Pierre, you actually had the picture of this election. So just to remind all of us, this was 2.5 months ago. Okay, what do we have now? We have, as we all know, crises are the times of the incumbents. It's the time of the executive. We have a record high for Chancellor Merkel. Timothy Garden-Ash the other day in an interview in the New York Times described Chancellor Merkel, sort of said how lucky the Germans are to have such a chancellor, and he described her as having the brain of sort of a natural scientist and the heart of a priest's daughter. So we have an all-time high of the CDU hitting 40%, incredible. Hardly, I mean, everybody is satisfied, or a lot of people are satisfied with the job our finance minister Olaf Scholz is doing. I think nobody really knows that he actually is the member of the SPD. The SPD, once again, is not gaining any support in the polls, and the big loser at the moment are the Greens with 15%. So there's a 25% gap between the Greens and the CDU at the moment. The CDU is united, and interestingly, why is it so united? And does it gain so much support? Because, and that relates to what you said, you know, you spoke about federalism and so on. It basically unites two extreme positions with, you know, the minister in North Rhine-Westphalia and the prime minister in Bavaria. So, what's my not really provocative, but what's my thesis? My thesis is, or my point is, that Corona will, in the medium term run, not change the path the political system in Germany was on. It actually is something like it sort of enforces it even more. And what are the most, where do we see the most? I would say that's my first point. In the next months to follow, we will have an even greater societal polarization. The unemployment rate will go high, economic consequences, so polarization, where we will see actually a stronger AfD again. The AfD is now down to, depending on what polls you look at, 8 to 10%. That will rise again, is my bet. Because of course we will have someone, or the AfD will find someone to blame again. It will be the government, but it will for sure also be Europe. The CDU will of course not hold its long-time high of 40%, will most likely drop down to something like 30%. Again, and we will have a the polarization in the society will also be shown in the party system. We will overall, in Germany, in the States, but also on the national level, most likely have a scenario we see in East Germany. in the eastern part of the country. So the eastern part of the country probably will be something like a laboratory where different coalition settings or different coalition combinations will be tested. That will most likely be then also an option for the state. I hate to say that, but as things look now, Europe will not be the winner of globalization. It's going to be interesting to see what Merkel will make out of her EU presidency in the second half of the year. It will be, she already said that, this big a Corona presidency, and it will probably be her last chance and last move to actually make this really sort of a Europe that is based on solidarity, where the solidarity aspect plays a very strong role. But I hate to sort of end on such a pessimistic note, but I don't think that will be that will have a very long duration. My 2 cents.
Thank you very much, Andrea Römmele. Before I give the floor to Annika Klafki, let me briefly repeat that this is not a closed shop discussion. You, the audience out there, are very warmly encouraged to participate and to ask questions and to make use of either the Twitter hashtag IFHV, by which we will know that your question belongs to this debate, and I can pick it up and deliver it into the panel. Or, of course, you can always leave a comment right here on Verfassungsblog, and we will also take notice, and that way you can be part of this, and that would be really great. And now let's move on to the legal basis of all of what we've been talking so far, which is the so-called Infektionsschutzgesetz, and Annika Klafki happens to be an expert of this matter, and the floor is yours.
Thank you very much. I also prepared a PowerPoint presentation, which I will share with you now. Just a second. Yes, so here it is. Yeah, so the subject I'm talking about is amendments to the infectious disease law, and the question which is raised is an antidote with deadly side effects. That was a great suggestion by Pierre Thielberger, and I'm very happy with this subject because I'm not really sure how to answer this question. To begin, I shortly wanted to show the constitutional background. So we have a concurrent legislative power of the Federation for infectious disease law, and the law enforcement is done by the Länder according to Article 83 and 84. So this is actually a typical arrangement for the German, I call it cooperative federalism, Christoph Möller called it executive federalism. So this is very typical in our legal system. Now briefly, what is the contents of the infectious disease law? We have a general section, then a provision for coordinative measures by the Robert Koch Institute, which is an autonomous bureaucratic institution on the federal level. However, the Robert Koch Institute has no decisive competences. It may only give advice and try to coordinate the responses of the Länder. Then there are reporting obligations, preventive measures, control measures, compensation rules, and penalties. Now, and this is very interesting, so the central norm of this pandemic really is paragraph 28 of the infectious disease law, because it contains various measures. First of all, it refers to paragraph 29 and following of the infectious disease law, where we have some more details about specific measures which can be taken in the fight against an infectious disease, for example, observation, isolation, or the prohibition to work. And then also in 28, para 1, sentence 2, there's a specific provision for the prohibition of assemblies and gatherings in order to combat an infectious disease. disease. And then, and this is very important, there's a very indefinite clause in paragraph 28(1) sentence 1, which gives the competent authority the power to actually take all necessary measures to combat an infectious disease. So as we heard before, of course, such general clauses exist in German police law. However, normally in normal times, they're never intended to legitimize like far-reaching intrusions in fundamental rights, but rather for milder measures, which are deemed necessary. However, at the moment, all these contact bans and prohibitions and everything is mainly based on paragraph 21, para 1, and 28, para 1, sentence 2. And this was vastly criticized and rightly criticized. And as Christoph Möllers already said, then there was a little reform, and they added a little half sentence to it, saying, in particular, the competent authority may oblige a person not to leave the place where they are located, or to do so only under certain conditions, or not to enter places, or to enter them only under certain conditions. So by this, they wanted to legitimize a lockdown. Still, interestingly enough, there's no restriction like on the level of the prerequisites to actually issue such a measure. There's no information about how severe must the infectious disease be. Can it be influenza? Can it be a cold or whatever? And there's also no limitation with regard how long this measurement can be in place, et cetera, et cetera. So actually, this reform does not really help with the problem that these statutes are not decisive enough to actually legitimize the unprecedented intrusions into fundamental rights which we witness now. However, because of the crisis, the courts have accepted it, as Leuthauser-Schnarrenberger pointed out before. So actually, another point of this reform process, which was much more elaborate, is the paragraph 5, which introduced this new, sort of emergency clause called epidemic situation of national scale. And according to this legal innovation, the Bundestag, so the federal parliament, may determine an epidemic situation of national scale under certain circumstances. And if they do so and determine this epidemic situation, that leads to a wide-ranging empowerment of the Federal Ministry of Health to issue orders and executive regulations without needing the consent of the Federal Council, the Bundesrat, where the Länder are represented. So in which fields may they do so? This concerns, for example, travel-related measures to facilitate the identification of infected travelers, exceptions from the infectious disease law in order to maintain the health care system, which is very indefinite again. Then executive regulations to procure, stockpile, and distribute medicinal products, for example, this protective gear, and then executive regulations concerning medicinal personnel and guidelines for medical treatment. All these measures are limited in time until the repeal of the epidemic situation of national scale by the Bundestag, or at the latest at March of next year. And also it says in paragraph 5 that the Ministry of Health may issue unbinding recommendations to enable the coordinated action within the Federal Republic of Germany. Now, there has been a lot of criticism concerning this empowerment of the Federal Ministry of Health. In the press, concerns were raised that this would be an Ermächtigungsgesetz. Even some were reminded of the Weimarer Notverordnung, and many people see authoritarian tendencies. However, I wouldn't be that harsh. So is this deadly for democracy or federalism? Well, I think no. I mean, truly, there are many flaws of this new provision. Some terms are indefinite, and etc. However, I think the current empowerments of the Ministry of Health are only related to very, very technical tasks where federal action, in my view, is quite reasonable. If we look at travel-related measures, I think it makes perfect sense that not each and every state has its own stipulations, which documents people have to provide when they enter Germany. Also, public procurement, I think that's interesting that people criticize that the federal level is doing that, because during the last pandemic, the swine flu pandemic, it was actually criticized by the states that the federal level didn't help with the procurement, because it makes it much more expensive to procure scarce resources as a single land than for the federal level. And especially, there are no powers of the Federal Ministry of Health relating to the real disease control measures. So there, the Federal Ministry can only give recommendation, which is basically nothing. So my only criticism actually is to safeguard the rights of the Länder, it would have been nice to foresee that also the consent of the Federal Council should be needed also for these executive regulations. Why? Well, because I think a pandemic is actually an evolving disaster, so there is enough time to actually deliberate with the Federal Council. And more than that, I think we need even a broader empowerment of the Federation, not of the Ministry of Health, but of the federal government. And this could be based on Article 84, Para 5 of the Basic Law, which says that the federal government may be authorized by a federal law requiring the consent of the Federal Council to issue instructions to the Länder concerning their execution of a federal law. So why is that? Not because I do not respect the states, but I think in this crisis, we witness that the steering or programming power of the federal law, the infectious disease law, is very low, because now the general clause of paragraph 28, other than ever intended, now serves as a gateway for completely unprecedented intrusive measures, which Parliament never had in mind when they put the provision in place. And I think now this considerable leeway of the states actually contradicts the system of cooperative federalism, how it was established, and also it's in breach with this constitutional vision of equivalent living conditions. Also, if we look at the legal corona landscape, it is highly diverse and complex. Not only the states, also the counties and cities issue new regulations and general administrative acts every 2 weeks. I think this is very negative concerning the transparency. I have the impression that a lot of people who are not lawyers do not understand which rules are in place at the moment. This also is negative for the acceptance of the people. In the beginning of the pandemic, people were also fine with some chaotic rulemaking because they were in fear of the pandemic, but now we witness something which I would call disaster fatigue. People are tired of this corona and are not willing to accept anything anymore. And so I think in this situation, the rationality of rulemaking is really of the essence. And I think this could be enacted by using this provision of Article 84 of the Basic Law. And I would suggest that this right to issue instructions should be limited to this epidemic situation of national scale. And before issuing any instruction on the federal level, for each and every instruction, the consent of the Federal Council should be needed, because that would ensure that there's a deliberation between the federal government and the heads of the executives of the states. Just one last sentence. I really like the idea of Christoph Möller's that the parliament should be more involved. However, in practice, I'm not sure whether that can actually happen, because if I imagine now a state parliament drafting a bill which actually sets out certain provisions for a lockdown, and now this bill wouldn't be successful, what would that do with the measures in place? I mean, then they would be totally illegitimate, and it would hard to argue that we can still place them on the general clause. So I think it is very risky also now for politicians to draft new bills unless they're absolutely sure that they will pass. So so that's it. I'm happy for the discussion.
Thank you very much, Annika. We have a question from the audience via Twitter, which is directed to Pierre and Benedikt. And the question is, who is supposed to provide the necessary financial means and personnel for centralized emergency capacities, Bund or Länder?
Very good question. I read the other day that the Schuldenstandsquote in Germany, that is kind of the, what is that in English? Does anyone know that? So the proportion of all debt relative to the GDP, essentially, that is expected to go up in 2020 by 15%. 60% to 75%, if I remember correctly now. So essentially, we're talking here about roughly 250 billion new debt, right? So, of course, less income for the state and new debt. So the costs are dramatic. That's why it's a very good question, whoever asked it. And the answer is, and that derives a bit from Annika Klawski's talk and also something I said before and Christoph said before, that is, of course, that the main bill currently is paid by the lender. Right? So the lender are dramatically underfinanced. That's for a start. The same goes for the municipalities, for the Kommunen. And the problem is that most of the measures fall in the competency of the lender, as we have just heard, and I think Benedikt mentioned it as well in his introductory talk. So maybe connecting this question to our prediction that this peace and quietness that we have at the moment won't last, maybe we could link it to that. Because in German we say, beim Geld hört die Freundschaft auf, right? So, and if we at the moment say the system works very well because we have this cooperative spirit and the lender and the Bund are working so well together, well, let us see whether that will last when the big bill comes, and the biggest part of that will come to the lender.
Thank you very much, Pierre. There's another comment via Twitter, which is directed at Andrea. Many are satisfied with the work of Olaf Scholz, but do not seem to realize he is SPD and don't give his party credit. What do you make of that? Oh, you're still, you have to switch on your microphone, I'm afraid.
Okay, can you hear me now? Yeah, I mean, that has been the destiny of the actually of all junior partners in governments, that you know, the senior partner always, or in most instances, gets the credit from voters, and that's also what we see now. So it's no big surprise. Now I can't hear anything. I can't hear you.
Right, yes, my mistake. Everybody makes this mistake in turn. Okay, another comment has come in via Verfassungsblog, which is directed, as far as I see, to no one in particular. So anybody who feels like answering that one is warmly encouraged to. The crisis in Germany presents a different scenario from the rest of the world. The democracy is more stable, and therefore some of the measures taken and the worries are different. The worries about the health of democracy and rule of law are similar, but in Brazil, for example, we worry about new legislation in this crisis situation, or the declaration of a state of defense, since these measures could tighten the grip of the president. Could you please comment more about these differences? Who feels competent to talk about the differences between the German situation?
Wenn ich ein Wort sagen darf, in Deutschland hat man weder Bund noch Land, egal wie man sie gewichtet, haben die Gelegenheit genutzt, um wirklich eine Veränderung des demokratischen Systems zu versuchen, zu initiieren. Wir sehen in anderen, auch europäischen Ländern, aber auch Brasilien, aber auch Russland geht gar nicht mehr so viel, aber gerade auch in europäischen Mitgliedstaaten, dass da doch versucht wird, diese Krise zum Anlass zu nehmen, um die Medien vielleicht noch stärker in ihren Arbeiten einzuschränken, also die Pressefreiheit noch weiter zu beschränken oder die Justiz in ihrer Zusammensetzung, in ihren Zuständigkeiten zu begrenzen oder Richter zu versuchen, durch neue Disziplinargerichte in ihren Entscheidungen, das gerade ein aktuelles Thema ist. Also Orban sagt immer, diese liberale Demokratie, die muss weg. Ich will eine illiberale, also ich will mehr ein stärker autoritäres System, was auf mich zugeschnitten ist. Und das ist positiv, dass das in Deutschland, denke ich, nicht versucht worden ist, dass wir hier Schwächen zeigen. Und mich würde sehr interessieren von Herrn Möllers, wie er sich vorstellt, wie man noch weitere Prozesse, neuere Prozesse entwickeln kann, um eben eine bessere Beobachtung, eine bessere Kontrolle, auch zeitnäher von Seiten des Parlaments gegenüber Bund- und Länderhandeln zu bekommen. Denn Sie haben ja zu Recht beschrieben, das Parlament stellt eine Frage, 3 Wochen später eine Antwort. Die Situation hat sich komplett geändert. Schon wieder ein neues Infektionsschutzgesetz oder wichtige Amendments dazu sind beschlossen worden. Also ich finde, das ist positiv in Deutschland, dass das nicht passiert ist, hier wirklich Systemveränderungen herbeizuführen. Umso wichtiger, finde ich, ist auch der Punkt von Herrn Thielberger, nämlich wie gehen wir nach der Krise mit Gesetzgebung um, die jetzt während dieser Corona-Krise erlassen worden ist. Warten wir die Befristung ab, Ende März 2021 und dann ist alles wieder schön wie früher? Oder ist der Auftrag da, dann zu sagen, eine Gesetzgebung zu schaffen, die auf Krisensituationen zugeschnitten ist? Und ich weiß nicht genau, ob Sie das auch aber ich habe Sie so verstanden, dass Sie das auch auf die Verfassung beziehen, dass man auch da sich Dinge überlegen sollte. Ich würde gerne wissen, in welche Richtung das vielleicht diskutiert werden kann oder ob sich das eben auf die Gesetzgebung insgesamt bezieht, weil man dann mit Beteiligung Parlament und Bundesrat eben doch eine ausgewogene Gesetzgebung nicht in Form vom Schnellschussverfahren macht, sondern debattiert und damit aber eine bessere Grundlage für künftige Pandemien oder andere State of Emergency hat. Das, finde ich, sind nochmal 2 Punkte, die ja mit unserer Verfassungsordnung zu tun haben, vielleicht eine Verbesserung anstreben, aber eben gerade anders sind als das, was wir in Ländern erleben, wo wir eher autoritäre Züge dann auch im System verankert sehen.
Max, may I quickly attempt to translate, because we don't know whether our friend from Brazil understood German. So maybe just the first part before Christoph Möllers answers the question. I'll just try to paraphrase what Frau Lotteser-Schnarrenberger says, unless you want to do it, Max. So essentially, yes, Germany is very lucky that no one at the federal or at the Länder level attempted actually to change the system. If you think about Hungary, for instance, or other European states where we do see those attacks also on the rule of law, on democratic processes. So it's not a problem that we are not familiar with in the European Union, even if in Germany, indeed, as was raised in the question, is not so much luckily a problem. Touching raised to you by Frau Lotteser-Schnarrenberger, I guess.
I'm afraid the line was, at least on my end, was hardly understandable. I'm afraid what you said because the line was disturbed. I hope you all, maybe you all could follow. Christoph, would you want to answer?
Well, perhaps just 2 points. I think first, one important point is to see that the strength of the German political system during this crisis is basically a strength of bureaucracy. We are a administrative state, we're a bureaucratic state. And it is so funny that, one of the paradigms of politics in Germany has been Bürokratieabbau, less bureaucracy, and so on and so forth. But that's the only thing German politicians actually know. Because making politics is not the strong suit, but executing rules, they are very strong in that. And this is our old tradition. It's not a really classically democratic tradition, but it has its advantages in times of crisis. So I think it's very important to see that. This is in a way an unpolitical, instrumentalist, but very effective and life-saving form we have here. And the fact that we are at the same time good bureaucrats and bad politicians is, I think, very well documented by the fact that we are doing so well in Germany while doing not really well in Europe by making real politics, but basically screwing that up more or less. So I think that is very important to see. And then we can wonder how to get back Parliament into the game. And I would probably not agree with Anita, but because I think the very regulations that the states are now issuing, and which are the core of the whole abridgment of rights that are at the moment in force, could have statutory forms. And there's no real danger that they don't get a majority, because basically if there's no majority, there's not even a government that could issue them, at least not with enough legitimacy. And on the other hand, what we would get with a proper parliamentary procedure, in which at least we get some reasons for that, we get some form, we somehow see what is going on there, while the clandestine form of executive regulation we are now confronted with is somehow not very satisfying, if it is constitutional at all. So I think this would be the minimum, and a little bit more of an upgrade for legislatures would be to have new review procedures, and would actually the rhythm of review between parliament and government is somehow dramatically accelerated, so that basically we should have expect state health ministers to show up every week in parliament, and interior ministers as well, and tell us what was going on last week with regard to the execution of these rules.
Annika Klafki?
Yeah, just to quickly respond to that. I mean, I have great sympathy for parliaments taking more power and actually issuing parliamentary laws. However, in practice, I have the impression that it's more difficult in this situation to enact laws than regulations and general administrative acts, because it's so difficult to foresee which measures will be necessary and will be adequate in the next 2 weeks. So actually to make a law which entitles lockdown to enter this generally into the infectious disease law, I think a lot of parliamentarians, wouldn't be all too comfortable with it. Also, I think in Parliament, normally, I think actually the drafts are not outgoing from parliamentaries, but from the ministries. And also for the ministries, I don't know whether there's much incentive to actually now draft bills and have them discussed for weeks in the Bundestag and the Bundesrat, or also on the state level, rather than just issuing the regulation. It's much easier for them. So those are some practical problems I see with the further statutory regulation of these issues. However, I would be very happy if it happened. So I'm not against it. I just don't know whether, or I'm asking myself, why is it not happening in practice? And that have been the reasons why I thought it is not at the moment.
Do you want to answer that? You have to switch on your microphone.
Oh, it is on.
Well, I think, first of all, I think it's quite easy to explain that, because I think there's a high degree of complacency of the majority caucuses in parliament. Their government is in charge, their government is successful, and they have, I think there's a problem that they have a political responsibility to back their government, but that is somehow a little bit neglecting the institutional responsibility they have towards parliament. And then I'm not really always buying that kind of, hurry up argument. Basically, the whole situation built up very slowly. We have been knowing since the end of February that something was going on. Everyone knew that there would be something like a curfew or something comparable coming up for weeks. And therefore, the fact that the parliament couldn't deliberate, or that we cannot deliberate the totally foreseeable reforms of that lockdown, the totally foreseeable Erleichterung and so on before, doesn't really seem to me altogether convincing. I think still that it is very comfortable for the majority in parliament to have a successful and somehow well-liked government doing their job. But this is obviously not an excuse not to do it themselves.
We have another comment on Facebook, which brings up the other part of the system to scrutinize the executive, which is the courts. Thanks for the great discussion. I have a more general question. What should be the role of courts in policing public health emergencies in the German context? The difficulty is that most of what courts can do is to say no to things. They can deconstruct existing responses, but do little to build alternatives. Even one of their alternative roles, to nudge policymakers in certain directions over time, is limited by the need for quick responses that constantly adapt. As a result, legal intervention is likely to deplete judicial legitimacy. What, therefore, is the role of constitutional review in the COVID-19 crisis? would you want to answer that, Ms. Starnberger?
I'll try. Die Aufgabe von Gerichten ist es nie, alternative Lösungskonzepte zu präsentieren, sondern, und das ist schon eine wichtige Rolle, auch in Corona-Pandemikzeiten, Maßnahmen zu überprüfen, auch für Einzelne, die sich an Instanzgerichte, nicht nur ans Bundesverfassungsgericht wenden, zum Beispiel an die Verwaltungsgerichte wenden, im Einzelfall dann zu entscheiden, ob zum Beispiel das Verbot, seinen Großvater im Altersheim mit Einhaltung von Schutzkonzepten zu besuchen, wirklich aufrechterhalten werden soll oder nicht. Also einfach einmal so Einzelfallgerechtigkeit zu geben. Dazu sind die Gerichte ganz wichtig, auch in Krisenzeiten. Und diese Möglichkeit, einstweilige Anordnungen, über einstweilige Anordnungen eine vorläufige Entscheidung zu bekommen, gibt ja den Gerichten die Möglichkeit, schnell zu reagieren. Also nicht beim Verfassungsgericht in 3, 4 Jahren dann mal zu einem Urteil zu kommen, wenn keiner mal weiß, was denn überhaupt damals die Krise war, sondern jetzt sehr schnell, das haben die teilweise in Tagen gemacht. Und da kamen dann auch nicht Alternativen, aber eben die Lockerungen zum Beispiel zu bestimmten Beschränkungen. Beim Versammlungsgericht ging das relativ früh und relativ flott erwartbar, bei anderen vielleicht vorsichtiger, bei Gottesdiensten ein bisschen zurückhaltender. Aber da, finde ich, erfüllen Gerichte schon eine wichtige Funktion, auch für den Bürger. Aber die sollen jetzt ja nicht der Regierung Dinge an die Hand geben, die sie eigentlich besser machen sollten, sondern das muss dann natürlich die Politik leisten. Aber wenn bestimmte Maßnahmen zum Beispiel auch als nicht rechtmäßig bewertet werden, ist das ja der Auftrag für die Regierung, ihr Handeln zu überdenken und Maßnahmen vielleicht auch zurückzunehmen. Von daher sehe ich das schon auch einen konstruktiven Part der Gerichte in so einer Krise. Aber eines, glaube ich, muss man auch sehen: Gerichte sind unabhängig, Richter sind unabhängig, aber sie leben und urteilen auch in einer bestimmten gesellschaftlichen Situation. Und wenn es eine Krise ist und alle reden davon und sie ist nicht zu leugnen, so, und wir leugnen nicht, dass es Infektionsrisiken gibt und die auch ziemlich hoch waren und nachher wieder besser in den Griff bekommen waren. Und wenn man das sieht, dann ist es schon eine Erfahrung, dass Gerichte dann eher in vorläufigen Entscheidungen sagen, jetzt lassen wir mal erstmal, sag ich mal, die Regierung handeln und fangen nicht an, alles gleich einzusammeln. Also da sind sie eher in der politischen Situation auch zurückhaltender, gerade auch Verfassungsgerichte, in einem Urteil, ob was jetzt wirklich verfassungswidrig ist oder nicht, sondern geben eher mal der Regierung auch ein bisschen Zeit, glaube ich, dann ihr Handeln weiterzuentwickeln. Und das schmälert aber nicht die Bedeutung der Justiz, nach meiner Einschätzung.
Thank you very much. Benedikt Behlert.
Yeah, thank you. I think that with regard to or the role of courts will be very interesting to see and to follow as we see more and more judgments also on the merits later. And one interesting parallel could be the European Court of Human Rights, which for emergency measures developed its famous margin of appreciation doctrine, where the court held that with regard to emergency measures and with regard to the determination of an emergency, states have, or state executives, governments have a wide margin of appreciation. Now, I'm not saying that this is the path that the Federal Constitutional Court should necessarily follow. However, we have seen such dealings of courts with emergency measures. However, one difference that is perhaps quite important is that the European Convention on Human Rights does have a provision allowing states to derogate from their obligations. So the European Court of Human Rights, in developing this doctrine, had a regulation that it could justify the different standard of review with, whereas the Federal Constitutional Court does not have such a provision.
Annika Klafki?
Yes, a very brief remark. In my view at the moment, the courts are something like a seismograph for social perception, because in the beginning of the pandemic, actually the courts, also the Federal Constitutional Court, accepted wide measures and didn't criticize it. They accepted complete prohibitions of assemblies, for example. And then suddenly after Easter, it completely changed, even though the epidemical situation in Germany has not really changed, and even though the infection rates weren't really so different to justify this. And this is something which I find very, very interesting, how context related these judgments are. And I think this will be an interesting research topic after the pandemic, like how the social perception of this crisis and the crisis management corresponded with the development of the court judgments.
Thank you. Before we have another question coming from Verfassungsblog, I would like to direct, if I may, a question to Andrea Römmele, because we've been talking much about lawsuits in courts, about fundamental rights infringements, and we are seeing right now on the streets what may be called an emerging movement of protesters who basically claim their right to protest in times of pandemic as well, their fundamental right to freedom of assembly. And some of those people are combining that sort of protesting for the right to protest with the most absurd kinds of conspiracy theories. And all this is propped up by an aggressive demand for fundamental rights painting the whole scenario in colors of strong constitutionalist language, right? Now, what do you make of this as an expert for political communication? What is going on there? What are we dealing with?
Yeah, thank you very much. Well, there is, from my perspective, there's nothing wrong with people sort of, exercising their fundamental rights by going out on the streets and demonstrating. I think that's fine. And I also think, and I was a little bit surprised, to be honest, at the first 2.5 weeks into our lockdown, that we didn't see this debate actually being stronger. What I'm worried about is this growing tendency, or these growing conspiracy theories, and this and the misinformation, the growing misinformation and disinformation we are observing in the public sphere. I think that is frightening. I'm wondering, I mean, and that's just a question I have. If we look at our public broadcasting station, at the ARD and ZDF mainly, right? I'm wondering, there are, of course, that there are no studies out there yet, but I'm wondering whether this is a kind of, to some extent, also a kind of counter movement, because from my perspective, I think they have overdone the information, their information duty when it comes to COVID-19. I mean, every single evening there was in the ARD, I think it's called Brennpunkt, and in the ZDF it's called Spezial. So you had like, the news were full of COVID-19, and then there was like an additional half hour, either in ARD and ZDF, on COVID-19, which I think was overdoing it a little bit. I mean, relating to what I said before, we in the political system and also in the media system, in the public sphere, we don't see new developments, but we see developments we have seen before COVID-19 more prominently and accelerating. So the whole filter bubble debate, the whole misinformation, disinformation, fake news debate is now in the crisis becoming stronger.
Right.
Can I ask a question or a follow up to this? A bit
Yes,
much. You said very rightly, I think, in the first 2.5 weeks, you were almost surprised how little, right? And I was too. And I remember all those newspaper articles in New York Times and everywhere and in Spiegel and wherever. And they all said, if all those restrictions that are happening now in China would be happening in a liberal democracy, people would never accept it. That was what we all believed, right? And it took so long. And so I agree with your observation, but what's the reason for it? What happened in those 2.5 weeks? Why didn't we see? Because everyone, I remember it very specifically. All the newspapers said what's happening in China could never happen in Germany, the UK, the US, wherever, but it did. And for a long time, there wasn't this reaction that we see now. Sorry, I just found it interesting because you mentioned
yeah, I was also very, very surprised about that, Pierre. Now, what's the answer to this? Probably a couple of phenomenons. Perhaps, I mean, if we really look at Germany from sort of a larger and a historical perspective, because perhaps there is something like, or some element of sort of Untertanenstadt. I don't know, but it would be worthwhile discussing that. I'm sure it was also partly strong leadership. I think Merkel in the first 2 weeks did a splendid job. I think, you know, we always discuss, at least in my political communication classes, you know, I have a section on speech writing and the power of speeches and so on. And I think her speech, to be very honest, was very powerful. And I think at least that might explain the first week. But that's only, you know, some ways to answer that question. It still is, I don't really have the answer to it. I think it's astonishing. And like you said, you know, we all looked at China and said, oh my God, how can that be? But just look around in your neighborhood for the first 2 or 3 weeks. It was incredible.
Es ist die Angst, die die Bürger umtreibt. Ich glaube, das führt mit dazu, dass sie bereit sind, weil sie selbst sich meinen, nicht selbst schützen zu können alleine, dann vom Staat einfach einmal Sicherheit und stringentes Handeln, gutes Auftreten, Vertrauen in Handeln des Staates erwarten und da auch bereit sind, einmal schon doch deutlich zurückzustecken. Ich glaube, das ist mit eine Emotion, die da mitspielt, sich so zu verhalten, mit Sicherheit nicht der alleinige Erklärungsgrund.
Annika Klafki?
Yeah, I think in psychology, one calls this shock risks. These are risks where many people die at one place in a very short time. And there were these pictures from Italy with all these dead bodies being transported, and also from New York. And I think these shock risks, which we also have in cases of terrorist attacks, raises somehow irrational degree of fear. On the other hand, the opposing psychological phenomenon we witness now, which is called disaster fatigue, where irrationally the fear ceases to exist, even though the situation has not really changed.
Right, we have 2 more questions, one for Andrea Römmele and one, I suppose, for the 2 public international lawyers on the table. Let's start maybe with the question to Andrea Römmele. Ms. Römmele argued that after an initial phase of support to the government, the crisis will reinforce polarization. However, I would like to know whether and why she thinks that this polarization will follow the cleavages that have mattered before the crisis. For instance, the protesters against the COVID-19 measures come from various political camps. Thus, how can we know if this actually translates into support for certain parties?
Very good question. I like the cleavage aspect particularly. Yes, I did say that we will have a growing polarization, but the question is along which cleavage lines. And I think a cleavage line we will see re-emerging is, and we thought we'd be past that cleavage line, is the cleavage line between materialism and post-materialism. And that also pulls, that also gets to the question, what role will climate change play in the public agenda? Will it be? It was very high on the public agenda. That was one of the reasons why the Greens scored so high in the polls. But due to record high unemployment numbers, we will see in not in a couple of months, but in a couple of weeks, we will go back to more materialist questions, and that is one of the reasons why if the Greens don't have an answer to that, it might be one of the reasons why the Greens won't score that high anymore. So this cleavage will be way stronger than it was before. And the AfD will gain in support again. They will scapegoat the European Union, they will scapegoat government, and will with their fair rhetoric they have been using with disinformation, fake news, and so on, will for sure play a very strong part in not only the polarization but the heated atmosphere we will find in a couple of months.
Right. And then there's a question on Verfassungsblog. It was said that in Germany, a provision like Article 15, European Convention of Human Rights, or 4 ICCPR is missing. How should such a provision be formulated, and how and by whom should it be applied or declared?
Yeah, that is a very good question. And I think that this is, of course, this would have to be very carefully constructed, and one would have to look at where do such provisions already exist, what are the dangers with these provisions, etc. So I'm not able now to give a clear-cut answer on this is what the provision should look like. However, some of the aspects that must be considered are already mentioned in the question. Who should apply it? As far as I'm aware, in the human rights treaties, it's usually the governments of states that declare an emergency, or it is the governments of states that declare an emergency. One could also think about more in the lines of what Professor Müller said, to have the legislator, the Bundestag, declare such an emergency. Another question is, and that goes back to the question that was asked previously, what should the review of such a situation be once a state of emergency is invoked? How should it be reviewed by courts? Should it be reviewed by courts after all, or should it not? To what extent, etc. So I don't think I'm afraid I'm not able to give a more satisfactory answer than that. Other that I am convinced that this limitation and warning function that such provisions fulfill are positive, they are desirable. However, there is of course great danger that comes with such provisions, and that's why it should be very carefully thought out. But I think Pierre wants to add to my maybe not quite comprehensive.
No. I just want to say that sometimes people say such a provision would do such a great damage and so on. And I mean, if it's sorted out the right way, it doesn't have to, right? We have a lot of states who have it. We have it in the leading we're not talking about any human rights treaties here, right? We're talking about the ICCPR, we're talking about the ECHR. These are not like just some treaties. So it could work, I'm sure. I think, and Benedict is right, I think we should be very careful to make now certain claims how it should look like. But I do want to say what the main function of this should be is that it's timely, very limited. Right? And that the main goal of such a thing is that we have a clearer transition and a fast transition back to the normal case without it, right? The non-derogation case. So I think that should be the overarching goal if one wanted to approach such an article. But I think not everyone is a fan of such a thing, I can imagine.
Thank you, Pierre. We have another quarter of an hour, and 2 more questions have come in.
I think
no, 3.
Say some.
Oh, of course.
So I think there is a very well taken point in proposing that, because I really think there is something like there's this spectrum of, loss of rights that is not really accounted for at the moment. But I think the core of the problem is perhaps less that we don't have a procedure. The core is perhaps more that we have such a balancing approach in rights. Basically, the invisibility is created by the fact that we always balance everything. And in a way, what we see at the moment is perhaps the bankruptcy of that approach. Because we just balance it away, and then we can say, it's just the same right as it was before. We just have another kind of balancing test because the facts are different. And this is very much the core. And there are two factors. Obviously, it's very smooth. So basically, religious freedom is somehow blown away, but it's just balanced. It's still there. That's what we say. And on the other hand, the problem is that we have social rights that are somehow balanced away because they have a weaker position. So basically, property, religion is strong. People who have entitlements and on welfare are weak. So we have this double inconsistency of balancing. So I would think that when we introduce something that you propose, I see the point. I think it's fair taken. I think there's a real problem that we somehow ignore the fact that things are different at the moment. But on the other hand, I think that the core of the problem lies at a different place. Because in a way, through balancing, we even eviscerate the necessity for that kind of procedure in the German system, and therefore I think we should really reckon with our doctrine and basic rights, and should really have a hard look on what we have been doing for the last 30 years and how far it is really feasible in times of crisis. Because so far we have, in a way, nice weather rights that are somehow distributing things that are there in abundance. But what is when real scarcity of freedom shows up? It's not entirely clear that we have the right approach to that. Thank you.
That maybe answers partly already our next question, which has come in on Verfassungsblog. A question relating to COVID-19 and our understanding of democracy. The right to assembly and association has been restricted to a great extent in the fight against COVID-19, even on the politically important 1st of May. On the other side, institutionalized politics and the administration were less affected. While both elements are essential for a functioning democracy, less formalized political movements were made quite difficult to exercise. However, if we think of non-governmental civil political movements' main political asset, it is the possibility to bring their protest to the street. Does the different degree to which institutionalized and bottom-up movements are affected by the COVID measures reflect a misbalanced understanding of democracy? And does such an understanding maybe fuel the extreme and its unsubstantiated movements that sadly are emerging now? I think this would be for Christoph to answer.
In a representative system, democracy lies in the majority, and so far we have majorities, and everything else is somehow a myth. All these silent majorities, imagined communities that are somehow against it, they could vote, and somehow unleash their protests. We see there are protests, and obviously there is a problem for many people in that, and legitimately so, because obviously the price is paid in a very unequal manner for these measures, and we will have dramatic social in consequence that we cannot really imagine so far. But I think to refer to democracy, at the moment, there's a problem in procedure, there's a problem in, a formalization of representation, but I don't see the silent majority against it that is somehow ignored. I don't really see that. It's not, it's not in parliament, it's not even in the polls, it's somehow nowhere. And therefore, I would be very careful to give this kind of diagnosis to the state.
Thank you. Then there is, before we run out of time, another question for Andrea. Hi, great discussion, thank you. I am confused though. Is ARD and ZDF government TV? Are ARD Extra and ZDF Spezial government proclamations? I must have misunderstood. Maybe Ms. Wömmele could follow up.
Yeah, is my mic on?
It is.
It is good. Yeah, thanks for giving the chance to clarify that. No, of course it's not state television, but it is state subsidized. What is very important, they make it very clear that they are independent, but of course they are paid out of out of fees, and it's public broadcasting television. But of course, they are not state channels.
Then there is another possibly final question for our panel discussion here. Compared to other European countries, for example, Italy or France, a critical fundamental rights discourse was present in the German mainstream media right from the beginning of the crisis. I think that this awareness of fundamental rights is one of the reasons why Germany's measures were, from a comparative perspective, quite light. This is more of a comment than a crisis, but an interesting one, I think. Who would want to answer this one?
I mean, yes, I think that is true. I think Germany's tradition since 1949 is, of course, that we have, you know, the fundamental rights in the center of our constitution, and we've influenced others in that regard. That is true. But of course, I do believe that the measures were light is also just also has other reasons on top of that, I would say. And that is that, of course, things come together, right? I mean, it is just very coincidental in many ways how this pandemic struck, right? So why was Italy struck so badly? There's a lot of things coming together there, right? I lived in Italy for a long time, and let me tell you, I think some of the reasons why there was a spread that was so bad is that people like to come together with their families and like in the streets and being together. And this is just a much stronger tradition on top, of course, for reasons that workers had come in and so on, and had affected Lombardia and so on. But I think the symptoms that we saw in certain countries were stronger in Italy, for instance, right? And it struck there first. And therefore, the measures were also stronger there. I think if we had the infection numbers that Italy had, if we had the infection numbers like that Spain had, and the worst of all, if you follow the news in the last days, the infection numbers that now the UK has, which is by far the worst, I think then we would also see much stricter measures in Germany, irregardless of our strong tradition of upholding fundamental rights.
Thank you. Annika?
Yes, I totally agree with that. I also think we were very lucky that we were not hit so hard by COVID-19, and we had some time to observe how other countries reacted, and time to deliberate what is the most reasonable way to act. And instead of having a complete lockdown, to have contact bans, which I think was a very smart idea in Germany. Maybe a bit more general comment. I think what we're seeing right now is that law is much less absolute than we thought before the crisis, and that especially risk regulation and the response to risk is very heavily dependent on the social evaluation of the risk. So therefore, any legal mechanism which is based on absolute values have their limits with regard to such risk. And this can easily be shown if you look at the death rates of, for example, cigarette consume or traffic risks. The death rates are much, much higher than COVID-19 will probably ever get. And still, we as societies would never accept huge restrictions on our freedoms in that regard. So I think that is something very important to learn from the COVID-19 crisis, that law is always a product of its context.
Thank you, Annika. One last question. Do you think that countries that contemplate constitutional emergency mechanisms should still be operating under that framework? What would be the dividing lines to differentiate between a generalized emergency and less serious situations that can be managed at the executive level without much jeopardy to the separation of powers?
I think it's a very good question, because who defines, whether state of emergency is appropriate? And when we look at France, we basically have it all the time, since the at least since the Islamists struck Paris, and then the exception becomes the rule, and all the critics, left-wing critics of liberal democracy, are somehow proved right, but perhaps not necessarily so. So you need really criteria, and therefore you need a deliberation of that. And that might be one reason why you should better not have an executive state of emergency, because this is something that is not really discussed anywhere. And especially the parliamentary system, it would be strange. And we know that the German Minister of Health planned him to delegate this power to himself, which would have make him a little, little Caesar in the realm of infectious diseases. That would be quite weird, I think. And so it's a political decision. There's nothing. As Anita said, there is no risk as such. There's only a risk with the social context and the social meaning. And therefore, there is nothing that can trigger the evaluation of something being an emergency by itself. So it's purely political, and therefore it has to get some procedure that is adequate to that.
Right. I think that's a wonderful way to wrap up our discussion. We're perfectly in time, which is a rare feat as well. Maybe due to this, for me at least, unused format. Thank you very much to all participants within or without this panel. I hope you enjoyed it as much as I did. And let me briefly announce next week's discussion panel in the same format, but on a slightly different topic. This next week, same Tuesday, same time, same place. The topic will be whatever it takes, COVID-19 as an existential, in brackets, crisis for the European Union. So it's going to be about the European Union. There's plenty of things to talk about under that, in that regard as well, of course, with panelists as illustrious as Christos Stylianidis, the former Commissioner of Humanitarian Aid and Crisis Management, my colleague Anna Katharina Mangold from University of Flensburg, Mark Dawson and Anna Bobic from Hertie School, Kim Lane Shepley from Princeton University, who will talk about Hungary, and moderated by my colleague Sinthu Bustevsky from Verfassungsblog. This is all going to take place next week in the same format as we have. It remains to me to thank the participants again and to wish you a pleasant evening, and all the best to you, and stay safe.
Thank you.
Thanks, everyone. Thank you.
Thanks. Bye.
Have a good evening.
Bye.
Bye.
Bye, Christoph. Very cute daughter, by the way.
Daughter.